Hello everybody and welcome to Legal Studies Unit 3 Area of Study 1, the Criminal Justice System Part 1. If you haven't already, please check out my health and human development videos if you are doing that subject, as I have uploaded Unit 3 and 4 videos onto my channel. This is my first legal studies video and I am currently studying law. Legal studies was my favourite subject at school. It's probably because I had a really good teacher. So hopefully I can make these videos enjoyable for you all. The focus of today's video will be dot point 1 and 2. The principles of justice, fairness, equality and access, and key concepts in the Victorian criminal justice system, including the distinction between summary offences and indictable offences, the burden of proof, the standard of proof, and the presumption of innocence. The principles of justice. Throughout the course of Unit 3, you will be required to relate certain concepts back to the principles of justice. So this table briefly defines them. There are other definitions as well, however this will ensure that you know what each principle means in a nutshell. So for fairness, fairness refers to having fair processes and a fair hearing. Laws should be fair and fairly applied. Equality, equality refers to people being treated as equals before the law and having the same chance to present their case as any other individual. And access, access refers to all people having the ability to understand their legal rights and to pursue them. Key concepts in the Victorian criminal justice system. Summary versus indictable offences. Summary offences are offences that are less serious in nature. They are usually heard in the magistrate's court and can be heard in the absence of the accused. They are heard before a magistrate with no jury. There are no juries in the magistrate's court, and charges must be laid within 12 months of the alleged offence. An example is traffic offences. On the other hand, indictable offences are more serious in nature. They are usually heard in the county court or the Supreme Court and cannot be heard in the absence of the accused. They are heard before a judge and the jury. The jury is only required if the accused pleads not guilty, and charges can be laid at any time. Some examples are murder and manslaughter. Some indictable offences, however, can be heard summarily if the court and accused agrees. This is the case when the indictable offence is of a less serious nature than other indictable offences. The indictable offences that can be heard summarily are stipulated in Schedule 2 of the Criminal Procedure Act 2009 Vic. An example is handling stolen goods valued at less than $100,000. Having the matter heard summarily may be advantageous for the accused person if they plead or are found guilty, as the maximum sentence in the magistrate's court is 3 years for one offence and 5 years for multiple offences. It is likely that a higher sentence could have been handed down if the matter was heard in the county or Supreme Court. It is also more timely than having a trial, and it is likely to cost less. The burden of proof. The burden of proof refers to the party who has the obligation of proving the case in court. The burden of proof usually lies with the party who brings the case to court. In criminal cases, the burden of proof lies with the prosecution. The only time the burden of proof is reversed is when the accused is using a defence. The standard of proof. The standard of proof is the degree or extent to which the party with the burden of proof must prove the case. The standard of proof in criminal cases is beyond reasonable doubt. If there is any doubt, the accused is to be found not guilty. The presumption of innocence. An individual who is accused of committing a crime should be treated as an innocent person until the charge or charges against them are proven beyond reasonable doubt. The presumption of innocence is upheld through the burden of proof. The accused does not need to prove their innocence, and the individual, once arrested and charged, usually has the opportunity to apply for bail. That concludes today's video. I hope that your knowledge of Unit 3, Area of Study 1, the Criminal Justice System Part 1, has been consolidated. As always, if you have any questions, feel free to leave them in the comments below or email me. Thank you.